Hello. Let's go ahead and get started. For those of you who don't know me, I'm Julian Koo. I'm professor here at Hofstra, and Dean Professor Lefton has asked me to run through a refresher on constitutional law for you here on and as you get ready to take the bar exam this summer. I hope you're all pretty this will all be very familiar to you, stuff that you've learned maybe from me in the past. So hopefully it will be mostly just a review, and the goal here is just hit some of the highlights. So let me go ahead and start my screen here. Okay, so the idea for today is to go over and quickly review some of the main topics. Hopefully most of these things will be familiar to you, but really targeted toward focusing on those topics that will be covered on the bar exam, but also to place it in the context of the way you learn constitutional law here at Hofstra. So that's the plan for this session, which I will hopefully keep very short so that I don't waste your time. So, um, and just to quickly keep it, just for clarity's sake, this is not intended to teach you constitutional law. You all have already learned constitutional law. This is simply to refresh your recollection and to highlight those things to focus on. I fully understand that there's so many materials that you're thinking about right now. There's so many topics, so many rules to remember. It's really hard to sort out what you really need to focus on. And this is really intended to help you focus your studies and sort of reignite your memories rather than to teach you things from the beginning. Okay. Now, let's just think before we talk about the subjects, let's think about uh, the, the way that constitutional law is tested on the multi-state bar exam, the multiple choice section of the bar exam. There are 25 questions always on the MBE, as Professor Lupton has told you. And 50% of the way to think about this from a Hofstra perspective is that 50% of the questions are subjects that you studied in your first semester of constitutional law, Con Law 1. And those tend to be those questions related to constitutional structure, meaning the organization of the federal government, its relation of the different branches to each other. So the power of the federal courts and the Supreme Court, the separation of powers between the different branches, and the relation of the nation and the states, the federalism questions that you're so familiar with. And that's the bulk of what you study in your first semester in constitutional law and Con Law 1. And then 50% of the questions on the MBE will be on individual rights. And those are things that are almost exclusively covered, in our case, all covered in Constitutional Law 2, your second semester of Constitutional Law. And those are topics like state action, the due process clause, equal protection, takings, anything related to individual rights protections under the Constitution. So the highlights there in Constitutional Law 2 are due process, equal protection, and the First Amendment, but there are also other individual rights that are protected there. So that's the way I think about this from the perspective of the MBE, right? So half of the questions are Con Law 1 and half of the questions are Con Law 2. Okay, so let's dive into this. There's a little more detail here to give you a sense of it's worth your time to study constitutional law. It would be worth your time even if it wasn't tested so frequently on the MBE and then also on the MEE. But because it's often tested on both the essay and the multiple choice section, again, it's worth quite a bit of your investment of your study time, your valuable study time. Okay. So the bottom line here is that con law is tested a lot for a single subject, and that's okay. You spent 2 semesters studying constitutional law, so there's quite a bit of material, but you've studied it already. So let's just try to focus on what are the highlights and what are the things that you need to really focus on. Okay, so the way I thought about this is, so we're starting with questions of constitutional structure, or to use Hofstra lingo, Con Law 1 topics. And the first topic in constitutional law, anywhere that you study it, is always the question of judicial review and the power of the US Supreme Court and the lower federal courts to review the constitutionality of a law passed by Congress or an act of the president. And so this is something you always start with in Constitutional Law 1, and you will encounter on the bar exam in the form of questions, even on the questions of Marbury versus Madison, which essentially just establishes that there is this principle that the Supreme Court and the federal courts have the power to review and invalidate acts of Congress which are inconsistent with the Constitution. Now, you may think this is obvious, but in fact, it's the foundation for all of the cases that you'll be reading in constitutional law, which is why we started with that case, to be honest. The holding of Marbury versus Madison is pretty straightforward, but it's worth keeping that principle in mind, and it's not infrequently tested. Okay. Now, there are a couple of related doctrines to judicial review. So Marbury establishes that the courts, the federal courts and the Supreme Court have the power to invalidate an act of Congress as being inconsistent with the Constitution. But the courts have created doctrines that limit the ability of the courts to exercise this pretty awesome power to overturn the actions of Congress or the executive branch. And there are three doctrines that are often tested, which I would also study in Constitutional Law 1. The first, probably the most important, is, well, maybe the second most important, is the political question doctrine, which is a bit of a fuzzy doctrine, but essentially holds that there are certain types of constitutional law questions that are beyond the power of the courts to resolve. And the court has created a series of standards that it applies to determine whether something's a political question. The paradigmatic case here is Nixon versus United States, which is not that Nixon, but had to do with a federal judge who tried to challenge his impeachment by the Senate due to procedural changes in the way the Senate conducted his trial. And the point is not that the trial was okay or not. The point of the decision by the Supreme Court was that how the Senate organizes its trial procedure is totally a matter for the Senate under the Constitution. It's a political question, meaning that it cannot be reviewed by the courts. The second doctrine that really limits the power of the courts is the standing doctrine, and you see this a lot in all sorts of litigation. And the idea here is, of course, that not anyone can bring a matter into court and challenge the constitutionality of anything. You must, in fact, even to go to use anything in court, you must have some sort of injury, an injury in fact, a real injury, usually an economic injury or a physical injury, rather than abstract injury. So for instance, you can't just allege that there was a violation because there was a racial discrimination by some government entity. You have to show that the racial discrimination was against you, the person who's bringing the lawsuit, not someone who was outraged that other people were suffering racial discrimination. Those are terrible things, but not things that could be brought into court with the proper standing. So standing really limits, therefore, to the courts to case what they call under the Constitution's Article 3, cases and controversies. Okay, and then the third limitation on the power of the courts to review cases is Congress itself. Congress has the power to expand, but also limit or even eliminate the jurisdiction of the lower federal courts and the Supreme Court, at least with respect to certain types of appellate jurisdiction, meaning the types of cases it can review. Now, the exact contours of what those powers are to limit jurisdiction aren't fully established, but there are definitely some powers. Congress can adjust the jurisdiction of the lower federal courts as much as it chooses, and even adjust the jurisdiction of the appellate jurisdiction of the US Supreme Court. So the way I always try to think about this as a student is courts have the power to overturn things, but the courts have created these three doctrines, or recognize these three doctrines that limit their power to overturn or review matters for constitutionality. Okay. So after we talk about the courts and their powers, I think it's next you always turn to the other two branches. And here, I think the way to think about this is Congress is given certain powers under the Constitution. The president is given certain powers under the Constitution. And it's your job to not know all of them, but know the key powers that are typically used to enact legislation or to carry out executive matters. So here are the key, probably the most well-known and important congressional powers. There are many congressional powers, but these are probably the ones that are most likely to be litigated, the most likely for you to think about when you're uh, studying cases which have been the most controversial. So the most important congressional power by far is the power to regulate interstate commerce. And I'm sure you all remember your cases in that subject. The other, probably the second most important congressional power is the so-called necessary and proper clause, which, as I'll talk about in a second, sort of allows Congress to take acts which aren't specifically delegated under the Constitution, which are necessary and proper to fulfill other constitutionally enumerated powers. So basically, if it's already given a power to do something, it has regulate interstate commerce, or perhaps to issue debt, borrow money on behalf of the U.S. government. It could therefore, as a famous case, McCulloch versus Maryland held, it can also charter a bank because it's necessary to fulfill its other powers, meaning to issue debt, borrow money, and tax. So those are some examples of, so it's not specifically delegated, but it's something which is given to, which is necessary to carry out some of the other duties that Congress has. Third, probably the most important power, I put it together, the spending and the taxing power. In this case, it's the power to spend money, but from our purposes, you would focus on the power to impose limitations on people who accept the money that Congress gives them, such as the famous case, states must raise their drinking age if they want federal highway funds, or they must raise Medicare eligibility if they accept federal Medicare funds. So those would be examples of things that the power, using the power to spend money to force people to do things. And then there's also the taxing power, which is the power to tax people, but also impose conditions. Most famously, if you don't do this thing, we'll tax you. So if you don't buy health insurance under the old Obamacare, so-called Obamacare healthcare plans, then you would be taxed, and that would be a legitimate power under Congress. Finally, there's of course impeachment, which I think is very familiar to those of you who've lived through the last couple of years. The power to remove executive officers, judges, and the president himself from office. Now, on the flip side, Congress has a bunch of powers, and so does the executive branch, but the executive branch powers are not fleshed out in quite the same detail under the Constitution. So we have here, I think these aren't the only executive powers, but let's just group them into three different categories. The first is a general executive power, so literally the executive power, which is the power to execute the laws that Congress passes. So whatever Congress allows the president to do, the president can go out and do it, the executive power. It's also been argued that even if Congress has not actually authorized the president to do something, there's some residual executive power to do things that need to be done. Although the contours of this have been debated. And the famous case here is Justice Jackson's concurrence in the Youngstown case, which famously set out three categories of executive power. One, where Congress has authorized the president to do something, and that's okay in most cases. One, where Congress has not authorized or said anything in particular, and in which case it's not clear whether the president can act. And then one where Congress has forbid the president from acting. In those cases, the president can almost never act, although there might be a few cases where the president might have power to act. The second category of executive powers that are specifically identified in the Constitution is the so-called war power, or more precisely, the commander-in-chief power. Again, this is hotly debated, exactly how much of this power is held by the president and how much of it is held by Congress under its declared war power. But there's little doubt the president is the commander-in-chief and has some residual power to order the military to act. It's just a question of just how far he can go without getting congressional authorization for the use of the military. And then finally, this is probably the least sexy power, but probably in some ways the most sort of day-to-day power the president has, because the president doesn't really act personally to do much. Much of his job is acting by appointing other people, officers of the United States, we call them, to carry out the laws. And so one of his most important powers is the power to appoint with the advice and consent of the Senate. And there's a lot of questions about what kind of limitations Congress can put on his power to appoint and also remove people that he's appointed. Can they fix terms for these people? In what situations can his power be limited? Can they appoint people themselves that he can't fire or supervise? This has been an ongoing debate. The bottom line, generally speaking, is the president has the power, in most cases, to appoint almost any officer who's acting under the power to execute the laws under the executive branch of the United States. And the idea here is the president's in charge and so should be allowed to appoint the people. But Congress can impose limitations depending on the nature of that person's job. So some agencies which are administrative in nature, which are not held to be purely executive officers, which have sort of legislative or judicial duties that Congress has given them, might be shielded from full executive removal and appointment, at least removal. But this has been a battle between the executive and Congress over the years, and the exact line between the two has always been contested. But the issue to keep in mind is the power to appoint, but really the fighting is over the power to remove, and to what degree can Congress limit the president's ability to remove someone who's acting with the authority of the United States government. Okay, so those are the main powers allocated to Congress, powers allocated to the president under the Constitution. Separation of powers refers largely to the doctrine that these powers cannot be combined, that they're separated, and therefore Congress can't exercise executive powers, and likewise the executive branch cannot exercise congressional powers. So those are the basic ideas here behind separation of powers. Okay. Now, federalism is another important concept that we talk a lot about in Constitutional Law 1. It's sort of lurking in the background of all our discussions of Congress. So federalism, I think, is best conceptualized. It's defined as the idea that power is divided between the national or federal government and the state governments, and that the Constitution is intended to maintain certain powers for the federal government, and and then other powers are protected and kept at the state level. And this is constitutionally mandated. It's not something that can be adjusted willy-nilly by Congress. And so a lot of the discussion manifests itself in ideas that Congress is limited in their powers. They can only act pursuant to something in Article 1, Section 8 of the Constitution, which grants them a specific power. So one example would be Congress can pass a law regulating interstate commerce or things that affect interstate commerce. But there's a limit. It can't do things which are unrelated to limits to interstate commerce or have no substantial effect on interstate commerce. And the reason there's a limit is because if Congress does not have the power, the idea is that that leaves the power to the states, of course, right? Federalism, the states have some inherent right to do things, and they do. They do a lot of stuff that the federal government is not really allowed to do. They regulate many areas of law, including ones you're taking for the bar, like family law, which is largely free from federal regulation because of these types of limits. Same thing with the spending clause. There are limits on the spending clause. Again, typically the idea is there are limits on these federal powers or congressional powers in order to protect the states. Finally, the Supreme Court has also recognized at least one power that the states have, which means that Congress cannot interfere, even if it's something within their delegated powers under enumerated powers under Article 1, Section 8. So Congress might have the authority to regulate interstate commerce of a subject, but even so, there's a further limitation, probably inherent in the 10th Amendment, which is today referred to as the anti-commandeering principle. And the idea here is that Congress cannot simply order state and local officials to carry out federal laws. Those people work not for them, but for the state governments. If Congress wants to carry out the laws, they have to order their own federal officials to carry out the laws. And the idea here, again, is to keep the federal government and the state government separate, not just blend them together and make them one big unit. And that really is the animating idea behind federalism. Okay. Okay, so now let's shift gears and to take a radical shift, and we now pass from the first semester to the second semester. And this, of course, is also roughly half of the questions that would be on the multi-state bar exam, the multiple choice section. And as we discussed in the first couple slides, also quite a bit of this in the essays as well. Okay, so the first semester of constitutional law, or the first or questions of constitutional structure, are really all about the federal government has the power to do something, or does it not have the power to do something. And it's really, we're focusing on the government and the allocation of power between the different parts of the government. Okay. In the second semester of constitutional law, we pretty much focus wholly on individual rights. And here the question is uh, not so much does the government have the power, but even if the government has the power, is it limited by individual rights that have been granted under the Constitution to people, or sometimes companies or entities? But here it's not, therefore, one part of the government fighting with another part of the government. It's the government fighting with an individual person. And the idea is that there are some rights granted under the Constitution that limit the power of either the state or the federal government, even if they're acting pursuant to their enumerated powers, but which are still limit their ability to take action. Okay, so when we could think about individual rights, that's what we're really interested in. Okay, so now there are three questions I'd like to ask most people to think about as you think about individual rights. And for me, the first question and the preliminary question is, can the person who's asserting that they have a right, do they have standing, as we discussed earlier in the first section? Meaning, have they suffered an injury? That, again, they can't just be outraged that someone else is suffering a violation of their individual rights. They have to actually be the one who's been injured. And was it government that carried out, or was it a private actor that carried out the so-called violation of the rights? One important thing to keep in mind here is that the Constitution only limits the government from violating your rights. It doesn't protect you from violations of rights by corporations or by other people. We have laws for that. We have many things that protect you from corporations and other people, but those are not constitutional rights. Those are statutory rights enacted by a legislature. So when you think about constitutional rights, you have to first establish their standing, and second, that the action being challenged was by part of the government, or at least by a private entity that's acting on behalf of the government. Okay. The second question to ask is, which part of the government is, now we go back to which part of the government, which part of the government is passing the law? And is it the federal government or the state government? Because individual rights limit each part of the government somewhat differently, depending on whether it's federal or state government. And then finally, the main part of the analysis that I hope all of you remember from your studies of constitutional law too, is what is the appropriate standard of scrutiny? Meaning, when the court looks at the law and tries to determine whether it violates individual right, it needs to consider, well, do we look really hard, which is a very strict level of scrutiny, or do we give some deference to the legislature when we review their whether their law violates someone's individual rights under the Constitution? Okay, so those are the three basic questions to analyze when you're thinking about the question of individual rights. Okay, now, as you might recall, the most important, how do we put this? The most important individual rights that are covered under constitutional law are the ones which were extended to the states by the 14th Amendment. And the 14th Amendment is the amendment which, the most post-Civil War amendment, which extended individual rights protections to limit not only the federal government, but also the state governments. That was a huge shift in American thinking, which we don't need to go into here. The key thing to keep in mind is that all of the rights that you have cared about, typically first, second, fourth, fifth, sixth, eighth amendments, all those rights that are protected by those amendments have been incorporated by the 14th Amendment and applied against the state governments. So the state governments are limited, just like the federal government is, in acting by those amendments and those individual rights. There's a couple sort of obscure examples, although these are subjects that you study in your criminal procedure class, which are not covered in our constitutional law studies, but technically it's constitutional law. And so there are two rights that have been not incorporated by the 14th Amendment. The fifth, the right to be indicted by a grand jury, and the right to a jury trial in civil cases. So those are things that are not incorporated in all cases against state governments. And so what that means is that even though you might have that right against the federal government, you would not necessarily have those two particular rights if against the state governments. Okay. So we talked about standing already. The general requirement is that a plaintiff must show a concrete personal stake in the outcome, some sort of injury in fact, right? Typically economic injury, physical injury. There have been cases where the court has recognized injury to enjoyment of um, of the environment or like a park that they use. Enjoyment of the park could be something where, and then there's some sort of limitation on the park. That could be something which satisfies the injury in fact standard. Okay, state action. Here, the general idea here is that, as I mentioned, government conduct must exist in order for the Constitution to apply. Or private actors, like a company or a person, could also violate the Constitution if they're acting with a close nexus or on behalf of, or where their action is attributable to the government. But also, you must also always be looking for a government link. Okay, that's the key idea here. So just to review this a little bit more, the paradigmatic example is the company town, where a corporation builds a town, they own all the public facilities like the roads and sidewalks, they've done all the street signs, they've done every little thing that normally would be done by the government. In that circumstance, the court has held that private entity is effectively like the government and can be sued for violating constitutional rights. It's a pretty extreme example. There aren't many examples, but maybe in some cases a mall might almost be like a government entity in some cases, although the mall isn't quite the same because it's not providing public services, it's providing private services. So maybe where a private association, a neighborhood association might be something closer to this, where they own all the sidewalks and roads, or they provide government facilities. So there's a lot of different uh, gray areas here, but in general, the idea is where the government is using a private actor to carry out state services, then that private actor can be um, sort of sued for violating the Constitution. There's also a famous case called Shelley v. Kramer, which is where the Supreme Court recognized that even enforcing a land covenant or essentially a contract provision could violate the Constitution. So, in other words, the state acts by enforcing contract provisions that are in violating that could also be a state action. So that one, a bit of an outlier case, but it's still out there as a possible example of state action as well. Okay. Okay, so now with respect to the 14th Amendment, so the 14th Amendment has is the middle three, the 13th, 14th, and 15th. These are all important amendments. They're all passed after the Civil War. But for our purposes, the 14th Amendment is the one we really care about. And in particular, I would focus on the highlighted language here, that the 14th Amendment's big sort of requirement is that, as I mentioned earlier, the state governments are now bound by the Constitution to respect individual rights. And the two big rights are state governments, the federal governments already were bound. State governments cannot deprive persons of life, liberty, or property without due process. This is the so-called due process clause. It also, in the Fifth Amendment, applies to the federal government. And there's a lot of different rights that are protected under the due process clause. The other big right that you keep in mind under the 14th Amendment, which probably is even more important, is that each state must provide equal protection under the law to all people. And so equal protection is another idea here. Equal protection is equal treatment and effectively a non-discrimination principle. There are also the Privileges and Immunities Clause, which is not heavily litigated today, more of a historical artifact, although it lurks out there. And the Citizenship Clause, which guarantees everyone who's born in the United States citizenship. So those are, but the key things that you want to take away from the 14th Amendment is due process clause, equal protection clause. Now, let's talk about the due process clause. There are two categories of due process, just to make your life more confusing. The first category of due process is called procedural due process, and It requires here, if you win your case, all you do is get a hearing. You have the right to have a hearing. It doesn't mean you win. All it means is you get process. So what this means, the government, before they do things to you, they have to follow a certain process that is fair in the circumstances. And we'll talk a little bit more about. But the key thing is that when you do this, all you get is the remedy you seek is a notice that something like maybe I'm being fired, I'm losing my government job, I'm losing my government benefits, and maybe a hearing is a chance to challenge the denial of my benefits or something like that. The other category of constitution of due process is the more sexy and exciting one, the so-called substantive due process clause, which restricts laws that preclude, restrict, or regulate a protected fundamental right. So here, the idea here is that here, this is where there's literally a right, and the government has very little opportunity or cannot invade this right unless it has a really extremely compelling reason. Uh, but in most cases, that means they cannot interfere with this right because of the due process clause. So in this case, if you win under a substantive due process claim, the government cannot regulate you at all. Whereas in the first case, procedural due process, if you win, all you get is a hearing, which is something, but it's not as powerful an impact as substantive due process. Okay, now with respect to procedural due process, the basic idea, as I mentioned, is you get a notice and a hearing, notice of the action the government's going to take, and a hearing for you to challenge the action the government's to take, only if the government is to take away a life, liberty, or a property interest. And again, this idea here is, as you learn in your civil procedure classes, process is fairness. Right? I have a chance to make my argument. Doesn't mean I win, but it means I get a chance to make my argument. So there might be the classic examples for procedural due process would be the right to before the government takes away your job, that maybe a government job, they have to give you a chance to challenge that interest, or a challenge or a right to refuse medical care. They have to give you a right to set up a process by which you determine whether or not you want medical care. More commonly, in the classic cases in this area of law, is property interest. So the most famous case probably in this area is this idea that the government can't just take away your welfare benefits if you're eligible for welfare without giving you a chance to prove that I really am eligible for welfare. Like usually they'll say, well, you make too much money, we're cutting you off or something. And you have a chance, the government can't just do that unless they give you notice that they're going to do it and a hearing that you have a chance to go and show what is the level of, that I really do deserve these rights. Or a government job, before they fire me, I get a right to sort of show why I have a right to keep my job. Again, those are property interests. And again, the only remedy is a hearing or maybe some sort of chance to contest your the denial of your property interests or liberty interests. The more exciting doctrine, substantive due process, as I mentioned, is really just if you win your case, as I mentioned, the government is stopped from interfering with your rights, right? So in this case, the key word to keep in mind here is identifying something which is a fundamental right. Fundamental rights are directly protected by the 14th Amendment, right? And the hard part is figuring out what is a fundamental right. And here the court just kind of meanders around, and the best strategy for you is just to memorize those things that the court has identified as a fundamental right, rather than try to come up with some sort of system for which ones are fundamental rights and which ones aren't. Because the court's not super consistent here, so I would just recommend just go with memorization here. So there is something called the fundamental right of privacy, and underneath this, the court has recognized a bunch of what we think of as sort of personal rights, rights to physical sort of action, I guess, physical freedom, I guess. And these are this includes the famous right to choose whether or not to have an abortion, the right to get married, the right to procreate or not procreate, the right to decide whether to use private education or public education, the right to have to parent your child, and the right to engage in any kind of sexual orientation that you choose. Doesn't quite capture everything, but it's a useful way to memorize these things. And these are things that the court has recognized are fundamental rights. What that means is therefore that in most cases, the government has to carry a very, very heavy burden before it can prevent you from exercising your rights. So it has to have a really good reason for them to be able to prevent someone from getting married or to prevent someone from being able to have children, like by forcing them to get sterilized or something. That these are so fundamental, the court will almost always prevent the government from acting unless they have some extremely compelling reason. And it's almost never the case that they do. But the key thing here is that first you have to show that the right you have is fundamental, and then you can sort of limit the government from restricting this right. But like I said, there's no clear way to know whether something's fundamental or not. So the best strategy is just memorize the ones that the court has already recognized. Okay, I know that's fine, but that's the best we can do in this circumstance. All right, equal protection. Here, equal protection is this idea which is intuitive to all of us. People should be treated the same if they're in the same situation. And if we treat the same people who are in the same situation differently, that's unfair, and that's a violation of equal protection. Now, it's hard to separate equal protection from the goal when it was enacted after the Civil War, which was not entirely, but mostly to prevent or to try to prevent the government from engaging in racial discrimination. And that would be a classic example where people are different races, but they have otherwise all the same characteristics. And the government gives one group one treatment and the other group the other. That would be a classic violation of equal protection. Okay, so, but of course, it doesn't only apply to race. And there's a mechanism for thinking about when such discrimination even exists. So let's just first think about the types of discrimination. Um, and uh, and remember, in all these cases, we have to look for government action, not private action. So here, does the government law discriminate on its face? Does the statute say we treat one race differently than another race? Is it discriminatory in how it's applied, meaning that the law doesn't say anything, but the government actors, when they carry it out, they definitely treat one race differently than another? Or is it discriminatory in effect only, where there's no particular plan to do so, but it ultimately the law has the impact of discriminating against one group versus another? in in most cases, in the equal protection context, this is not true in statutory cases, but for constitutional law purposes, the Supreme Court has been pretty clear that either a law is, if it's discriminatory on its face, where it says literally, say, black people are treated this way, white people are treated another, then that's a violation of equal protection. If the statute says nothing about race or any other characteristic that would violate equal protection, it's neutral on its face, then a plaintiff must show that there's both a discriminatory effect, meaning one group is being hit harder, but also that the purpose of the law is to uh, discriminate against this one group. So the classic example is this case called Washington v. Davis, where the Washington City Police Department gave a test, and there was no evidence to test for people who were applying to be police officers the purpose of discrimination. There's a lot of evidence that, in fact, the police department did not want to discriminate on the basis of race. But the effect of the test was to make it much harder for one racial group to get jobs than the other. In that case, the court said, well, it may have this effect, but if the purpose was clearly not to discriminate, in fact, quite the opposite, then it doesn't count as a violation of equal protection. Okay. So in the context of equal protection, there's the way to think about this is you have to first identify not the right, but the classification. And depending on the type of governmental classification, different levels of scrutiny apply. The highest level of scrutiny is something called strict scrutiny. And if the case is governed by strict scrutiny, then the state has the burden to show in a court case that it's necessary, the law is necessary to fulfill a compelling interest, and that the state tried to every other possible way to accomplish the goal that it has, and this is the least restrictive way it could do so. In other words, it tried every other alternative, and this is the best it could do. Okay. Now, what the categories that trigger this level of scrutiny are, as recognized by the court, race, and this goes back to the history of the 14th Amendment, which is to prevent racial discrimination. So, anytime the government classifies on the basis of race, um, the court will conduct this kind of strict scrutiny and must say, look, government, you got to show me that you have a really compelling interest and that you did everything else to try to avoid using race in your classification. The other category where the government has recognized this is alienage, which is discrimination against people who are not US citizens. Um, that would also be something where the state has to show compelling interest. Religion, same idea, and national origin. So immigrants who come from another country. All those things are categories where if the government starts classifying, say, one religion in this way versus the other, in all those cases, that triggers strict scrutiny. And the state has the burden to demonstrate it has a compelling interest if it's going to classify people by these different categories. Okay. And just in general, the bottom line is you almost always lose these cases if it's in these circumstances. Okay. Intermediate scrutiny is is triggered by other types of classifications. And in intermediate scrutiny, the state has an easier chance to show to carry its burden. The burden is lower. So in intermediate scrutiny, here the example would be gender discrimination. The basic idea here is that when the government classifies by gender, meaning it treats women differently than men, all the state has to do is show the law is substantially related to an important interest, not that it's compelling and necessary to carry out a compelling interest. So this is a lower burden. It doesn't mean it can survive very easily, but it's a lower burden. And so illegitimacy, meaning that people who are not parents were not married when they're born, it's also something where the government can classify people, but it has to show some basic that there's a really important interest and they're classifying because of this really important interest. So here the example for gender is interesting because, of course, we can all think of examples where the government classifies by gender, right? So they have women's sports in college or public colleges, right? So they divide up men and women by sports. They don't have them play sports together. In the army, they don't, at least until recently, they didn't permit women's soldiers to do exactly the same things male soldiers did. So there might be other examples. The education is one example where there's, even though there might be compelling reasons to have a women's college and a male college, in general, the court has been very skeptical. And so even though the burden is pretty low, the court has invalidated gender discrimination in higher education on the grounds that, well, there's no real important interest here that we're trying to carry out, and that we need us to separate people by gender. So although the burden is lighter in gender, it doesn't mean that the government can willy-nilly discriminate on the basis of gender. And finally here, this is the so-called rational basis scrutiny. Here, this is the easiest burden for the government to carry. And this essentially means the government can discriminate as long as there's some rational reason to carry out some legitimate state interest. So this means that anytime we're going to claim for protection, unless it's race, alienage, or one of the categories we just discussed, gender, if there is we subject it to the lowest level of scrutiny. So the classic example would be from one of the cases, the pushcart vendors. One group of pushcart vendors selling in the street had been there 10 years and they got to keep their licenses. But anyone there who'd been less than 10 years didn't get to keep their licenses, right? This is unfair to one group versus the other, all pushcart vendors. But the court said, look, we're not going to review this in the same way that we'd review a racial discrimination case, right? Now, the court has been more skeptical of any laws that discriminate against those who have mental disabilities or laws that discriminate on the basis of age. And they might find that those laws are unfair and illegitimate, and therefore would be a violation of equal protection, even under this standard. But it's still very rare for a court to overturn a decision by a local government or a state government or a federal government to classify people based on age or mental retardation or mental disability, unless because the standard here is very generous and very deferential to the government. But it has done so in some cases. Okay. Now we're rounding toward the end here. So as I mentioned, I think if you dig deep into the due process clause and the equal protection clause, you're probably 90% of the way there. But there are other individual rights protected in the Constitution. So let's talk about a few of them. They're pretty not obscure, but not as sort of hotly tested. Let me just sort of go over one, probably the most sort of non-due process, equal protection law that's worth talking about, which is the so-called takings clause, which is a limitation in the Constitution on government taking private property, typically land, without compensating you. And so the classic example would be they condemn your farm and they build a highway on top of it, or a railroad, or Barclays Center, or something like that. The general rule is that they can't do this. The government can't take your land unless they give you just compensation. All right, that's a pretty straightforward rule. Now, where the case law gets tricky is where regulation. So the government doesn't actually take your land, but they adopt a regulation that effectively eliminates the value of your land. So imagine you bought a seaside property and you want to build a hotel, and then the government rolls in and says, actually, no, you can't use that land for any development at all. Nothing, can't build anything. In some cases, that might constitute taking, although the court has not required compensation in those circumstances, but they have allowed people to make challenges for what they call regulatory takings. So a few other kind of obscure but kind of interesting limitations and protection of individual rights. So Congress cannot punish you by passing a law just about you. So they can't say, all right, we're just going to prohibit Julian Koo from doing X or Y. This doesn't happen very often, but sometimes Congress, for instance, has tried to prevent certain foreign companies from doing things because they feel like they're dangerous, like Russian or Chinese companies. And those potentially could be a bill of attainder laws if they name the company. Ex post facto laws, Congress cannot pass a law which essentially makes something a crime after the fact. They can't, for instance, say, well, you're now, when you committed the act, it was not illegal, but now it is, right? So that's ex post facto law. And finally, contracts clause. Once a contract is enacted, state can't pass a law just says, okay, we nullify this contract clause post hoc, right? Contracts are protected. So this has been most commonly applied in the context of pensions, like you promise pensions over 20 years, and the state says, actually, no, we're not going to find the people bound to pay the pensions out 20 years from now. So they can't do that. They have to compensate you or give damages or whatever it would be. You can't just nullify a contract after the fact. Okay, so those are some other protections. Okay, in the home stretch here, the last few minutes here, let me just roll through what we call the First Amendment freedoms or rights protected under the First Amendment. And this could be a whole course, but we do discuss it in constitutional law too, and it is heavily tested on the bar. Okay, so the First Amendment protects two categories of rights that we care about. One is speech, that you're quite familiar with, speech and assembly. The other is religion. So we'll talk about speech first, which is the more complicated one. In general, speech, there are two categories, maybe, or two tests to keep in mind when we talk about First Amendment protections of speech. So the first thing to say is that most speech is protected, and it's protected up until the speech itself will lead to an imminent lawless action. So the classic example would be, you can march around and shout hateful, racist things. That's the Brandenburg case. You can wear your Nazi uniform. You can wear your Ku Klux Klan uniform. Unless you actually are about to say, and let's go out and do something illegal, like beat up people or commit racist acts or commit violent acts. All the speech up until you go to the about to commit the crime is protected. Okay. This is the so-called Brandenburg test, which essentially says all kinds of speech are protected if it doesn't fall in the second category. but most speech is protected up until it goes to the point where it will actually lead to illegal activity. Um, and the illegal activity would have to be almost immediately after the speech, or caused by the speech, or imminent. And it's quite difficult to meet that test, which is why people can do all sorts of crazy things and say all sorts of crazy things. As long as it doesn't lead imminently to illegalities, it's protected under the First Amendment. Now, having said that, there are some categories of speech that are just not protected at all, or have very, very low protection under the First Amendment. The most common example of this is probably obscenity. So, although people think it's protected, it's not really protected by the First Amendment. Meaning that now the problem. So, in other words, if the speech is obscene or like something like pornography, even there's no First Amendment protection for pornography, right? It's obscene. Now, one of the problems here is that people say, well, no, it's art. It's not pornography. It's not obscene. So there's some fighting over whether things are obscene. But if it is obscene, then it's not protected at all, and the government can ban it. Same thing with fighting words. Words that are just insults that are intended to sort of be used in, literally to start a fight have historically not been protected. And another category would be lies, right? You can't go out and lie about people, and that's not protected by the First Amendment. Okay, so those are things that, so the general rule is very protective. Almost every kind of speech is, unless it leads to illegal activity, is protected by the First Amendment. But there are certain categories like obscenity or fighting words where it's totally unprotected. Okay, now there's also some other protections in the First Amendment. Probably the most important ones would be freedom of association, which essentially means that you can't be forced to join an organization you don't want to join. On the flip side, if you do join an organization, you can define the membership to leave out certain groups if it's a private group. So the classic case allowed the Boy Scouts to say, look, we're not going to allow homosexuals to join our private association. And on the flip side of that, you can't be forced to pay dues to a union that you don't want to join. And so the court would call that compelled speech. And finally, there's one other interesting category that's worth noting here is that speech itself doesn't have to actually be words. It could actually be some sort of physical act. So the classic example here would be flag burning, where the court said there's an act that's illegal, burning the flag, but if it's part of this expressive conduct, sending a political message, we'll protect it as speech. And so one of the difficult things again here has been, well, you're not saying anything, but you're doing stuff. You're wearing something, you're wearing colors, you're doing things that are physical activities. Does that count as speech? And flag burning definitely does count as speech, even though you're not saying anything. Whether other things count is always a matter for some disputes. Okay. All right, last topic, and then we'll cut this if you're still with me at this. Freedom of religion. So here I'll just note that there are two categories under religion. And the first category cases are the Establishment Clause cases, which are all about whether or not the government is too closely supportive or promoting of a particular religion. And the idea here, the Establishment Clause is actually a disestablishment clause. Congress shall not establish any religion, and the court has interpreted this mean shall not favor any religion. And the two areas of fighting have been where the government has been deemed to be providing financial or other support to a particular religion. Typically, the fight is over religious schools. Can they give school vouchers to religious schools? Can they give support for busing for religious schools? To what degree would that be too much supportive of one religion over another? And then the other would be these so-called school prayer cases, typically, where the government it's not really providing financial support, but it's endorsing religion by putting a cross on the courthouse or outside the courthouse, or a Hanukkah or Christmas display or school prayer. All these things the court has held might be impermissible endorsements of religion, and therefore would violate the Establishment Clause. The jurisprudence here is a little messy, but I think the bottom line here is that the aid to religion cases, the court has said you can't aid religion directly, but if you give money to taxpayers and they want to use it for a religious school, if they're using it for non-religious reasons, that's fine. That's been a pretty permissive reading of the Establishment Clause. On the flip side, the court has said, look, we're not going to get too bent out of shape over school prayer as long as there's no element of coercion. So for little kids, if the teacher's out there saying, let's take a prayer, that's one thing. We think that might be coercive, but college, higher education, we don't think so. And there's but there's a difficult line drawing in a lot of those cases. Um, Finally, there's the free exercise clause. And here, this is the classic idea of freedom of religion, which is you can't prevent me from essentially doing things that are part of my religious beliefs. Now, this is not just, believing in a religion, but also actually doing things that are religious, like, I will take the sacrament on Sundays, or I will, eat a certain food for religious purposes, or not eat a certain food for religious purposes. All these things are protected. But what's interesting here, the Supreme Court has been quite controversial in its famous decision, Employment Division versus Smith. The court held that, okay, that's fine, you can believe in whatever religion you want, that's protected. But if we have a law that's passed which is not aimed at any religion, there's a general non-religious reason why we're doing this. In this case, there's a law regulating drug use. The fact that your religion requires you or encourages you to engage in certain use of drugs is not a defense to this law, because the law was not intended to prevent your religious activity. It's just intended to prevent drug use. So this led to lots of controversy, but the bottom line is that this is still good law. So that while you have the right to religion and religious practice, if there's some neutral secular reason to prevent that religious practice, and it's not a law that's targeted at religion, Supreme Court has upheld it, and that's been a pretty strict limitation on the free exercise clause ever since that decision in 1992. Okay, so that's it for me here. I guess I've had enough. I'm sure you've had enough. I hope this gives you a highlight, and really the goal here should be to focus on the key things you need to remember. There's a lot more here that we didn't talk about. There's a lot more detail that we didn't do, but don't sweat the details. This is just to give you the list of topics, make sure you are familiar with all the terminology, and that you focus on memorizing the rules in these particular categories. I think you do great, and I'm excited. So I will stop here, and I will hopefully good luck on the bar.